हेलो गाइज, साइंश शॉर्ट हैंड स्टेनोग्राफी सेंटर गोविंदपुरी दिल्ली में आपका स्वागत है। आज मैं आपको लीगल डिक्टेशन नंबर 3 डिक्टेट करने जा रहा हूँ। यस एंड स्टार्ट। दिस अपील हैज़ बीन फाइल्ड अगेंस्ट एन order dated 11th July 2025 passed by the adjudicating authority National Company Law Tribunal in IA number 5365/2024 full stop. This application was filed by the appellant praying for various prayers which has been noticed in paragraph 1 of the impugned order, which is as follows full stop. To adjudicate the present application and declare that the land at plot number R05 at measuring about 571.33 square meters and it does not form part of the liquidation estate of the corporate debtor as per the provisions of the Insolvency and Bankruptcy Code 2016 and the rules thereunder and or and to direct the respondent to hand over the peaceful possession of above mentioned land to the applicant herein and or to direct respondent number 3 to relinquish its claim or interest in the said property as the permission granted by the respondent number 1 for such relinquishment is unjust, inequitable and contrary to the legislative intent and or to direct the respondent number 1 to move an application before competent authority of MPID for release of the said property in favor of applicant by virtue of order dated 10/5/2021 passed by the Honorable Tribunal full stop. Learned counsel for the appellant submits that after being filing the IA number 5365 of /2024, appellant filed another IA 1430/2025 which is pending consideration full stop. He submits that apart from the appellant who is a landowner, other landowners have already filed an application which is pending consideration, which the issue regarding increase in FSI has been sought to be raised full stop. It is submitted that adjudicating authority while deciding the IA number 5365/2024 has made observation in paragraph 5.13 that with respect to dispute to the entitlement to increase in saleable built up area full stop, it is open to be decided by a civil court having jurisdiction full stop. It is submitted that said observation shall prejudice the appellant since the issues regarding the increase in FSI is pending consideration before the adjudicating authority itself in the application filed by other landowners including IA number 1430/2025 filed by the appellant full stop. Learned counsel for the respondent submits that insofar as the observations made in paragraph 5.13, it is open for the appellant to press his company application within bracket 80 within bracket INS number 2029/2025 and other applications pending before the adjudicating authority, and observations made in paragraph 5.13 may not come in the way of the appellant full stop. He however submits that so far as other prayers, the order of the adjudicating authority needs to be affirmed full stop. We have considered the submissions of the counsel for the parties and perused the records full stop paragraph. The adjudicating authority, while dismissing the application IA number 5365/2024 and the prayers made therein, has given the reason in different subparagraphs of paragraph 5 full stop. Observations made in paragraph 5.13 which are relevant full stop. The learned counsel for the respondents submits that a revival plan is under consideration and the treatment for landowners would be in line with what is provided under their respective development agreements full stop. Therefore, if a revival plan gets through, the applicant would be able to enforce his rights as per the terms of the development agreement full stop. As regards the dispute with respect to the entitlement to an increase in saleable built up area, we leave this issue open to be decided by a civil court having jurisdiction on the basis of oral and documentary evidence full stop. We are of the view that this tribunal is not competent to determine the same full stop. As noted above, the appellant itself has filed as an IA 1430/2025 regarding increase in FSI which is pending for consideration full stop. When the adjudicating authority is considering the said application and other applications of other landowners, we are of the view that it is open for the appellant to press his application before the adjudicating authority, and the observations made in paragraph 5.13 that issue will be open to be decided by company application within bracket 80 within bracket INS number 2029 of 2025. A civil court cannot come in its way in deciding the application in accordance with law full stop. Paragraph. We make it clear that we are not expressing any opinion on the merits of the said application, which is not subject matter of this appeal, and the adjudicating authority, without being influenced by any observation in paragraph 5.13 as noted above, shall proceed to decide the application IA 1430/2025 in accordance with law full stop. With these observations, the appeal is dismissed. Stop and over.